Welcome, everybody. Good evening. I'm really happy to welcome you all here to honor Jim Greiner on his appointment as the Honorable S. William Green Professor of Public Law. I'm pleased to extend a warm welcome to Mrs. Patricia Freiberg Green, Bill's wife, and to Mrs. Cynthia Green Collin, Bill's sister. Thank you both for being here. To Jim's wife, Jennifer Lewis. Pat so generously provided the funds to establish this chair in memory of her husband, the Honorable S. William Green. Pat, you've been a wonderful steward of Bill's legacy, and we're so grateful for your gift. And we're so honored by your presence here tonight. Thank you so much for being here. Now, I'm going to try to talk as little as possible so that Jim can talk as much as possible, but there's stuff I have to say. And so before I tell you about Jim's background and career, I just need to say a few words about the creation of this professorship and about the wonderful Honorable S. William Green. So Bill Green, as he was known, was born in New York City, and he grew up in Manhattan. He graduated from Harvard College in 1950, and he earned his J.D. magna cum laude from this law school in 1953. After graduating from the law school, he served both in the U.S. Army Judge Advocate General Corps and as law secretary to the late D.C. Circuit Judge George T. Washington. In the 1960s, Bill served as the American Bar Association's observer to the U.S. mission to the United Nations under the mission's non-governmental observer program. And from 1955 to 56, he practiced at Cleary Gottlieb before joining Paul Weiss in 1968. Bill then went on to a very successful political career. He served as an 8-term U.S. representative from New York's 15th Congressional District. He was elected to Congress in a special election in 1978. He replaced Ed Koch, and he served until January 3rd, 1993. For 2 terms, he was House Chair of the Environmental and Energy Study Conference, which was then Congress's largest legislative service organization. And he was appointed by the Speaker as one of the House members on the U.S. Holocaust Memorial Council and on the Franklin D. Roosevelt Memorial Commission. Pat and Bill have 2 children, Catherine and Louis. And after a terrific life, Bill, after a courageous fight against cancer, Bill passed away in 2002. Bill was a dedicated public service. He built bridges, and he worked across the aisle during his time in Congress. His service was a testament to the greater good that can come when we dedicate ourselves to the well-being of society first and foremost. As the New York Times said in Bill's obituary, he, quote, achieved the delicate balancing act of pleasing both his fellow party members as they grew more conservative and the liberal voters of the east side of Manhattan. That is quite a balancing act. It goes without saying that the world could use more people like Bill Green today. So it is fitting in this year, when we are still celebrating the law school's bicentennial, to note, just want to make sure you all know we are still celebrating, that as an undergraduate reporter for the Harvard Crimson, Bill wrote an article that traced HLS's history from its origins to the mid-20th century. The article was called Law School After 152 Years of Ups and Downs, Plans for the Future, Floods Nation with Noted Lawyers, Public Servants. Bill wrote then of the school's commitment to public service and its role in training students for government service. Little could he have known that he would become one of the law school's most noted lawyers and public servants, a model of the very kind of integrity and professionalism that we still work hard to instill in all of our graduates. Soon after passing, soon after Bill's passing, Patricia Freiberg Green made a decision to memorialize his legacy by making a gift to Harvard Law School to establish a professorship in his name. And we have a certificate to read to Pat to commemorate the occasion and to thank her for the chair. So I'll read this and then I'll come hand it to you. It says, with profound gratitude to Patricia Freiberg Green for establishing the Honorable S. William Green Professor of Public Law, in recognition of Patricia's generosity to the law school and in tribute to Congressman Green's exemplary public service, with great appreciation and pride, Harvard Law School presents this certificate on the occasion of Professor D. James Greiner's appointment and inaugural lecture, April 5th, 2018. So. Okay, now on to Jim. It's really fitting that Jim Greiner assume a chair dedicated to public service. Jim's academic journey began at the University of Virginia, where he earned his BA with high honors. He was a member of Phi Beta Kappa, and he received the Stevenson Prize, which is awarded to the Government Honors Program's top graduate. Jim is also a magna cum laude graduate of the University of Michigan Law School. He was articles editor on the Michigan Law Review and a Bates Memorial Scholar, which goes to the top 3 graduates of the law school. After law school, Jim clerked on the Fifth Circuit for Judge Higginbotham. He worked in the Federal Programs Branch of the Civil Division of the Department of Justice. Tell me if I'm getting any of this wrong. Am I doing okay? And then spent 3 years at General and Block, where he litigated lots of complex cases in lots of different areas. He's a real lawyer. He understands the profession very, very well. And then he chose to give all that up to come to Harvard to study statistics. And he earned a PhD in statistics in 2007. His dissertation title is this, Contributions to Law and Empirical Methods, and that was highly predictive of his scholarship to come, even though he did not arrive at the title through a randomized controlled trial. Thanks. I was really, even if that was polite laughter, I'll take it. Jim is the kind of faculty member that a dean dreams of, especially a Harvard Law School dean. This is my first time introducing a colleague for a chair lecture, and I couldn't be more thrilled about it. I was on the committee that evaluated Jim for tenure, and I realized then, reading all of his work at that point, and this is a number of years ago now, that Jim is the kind of scholar who has the capacity to think about the way, to change the way we think about law. And he's well on his way to doing that. He came onto the teaching market highly trained in statistics, and his job talk paper challenged conventional ways of doing empirical work. He pressed for legal scholars to use randomized controlled trials to test empirical propositions, right? That's not typically the way that lawyers have done empirical work. And now he applies those techniques to the vital questions of access to justice in a time of shrinking resources for legal aid. The Access to Justice Lab, which Jim founded at Harvard Law School in 2016, has the ambitious mission of transforming law into an evidence-based field and to make the U.S. legal system work for individuals and families who cannot afford lawyers. He wants to make the law more scientific so that it can be more effective. It's Jim's contention that just as medicine relies on randomized controlled trials to judge the efficacy of different medical approaches, we lawyers should use the same techniques to evaluate the policy solutions we apply to easing the problems of access to justice. Now, this I want to say about Jim, and it's very important. Jim is fearless and courageous in the pursuit of his work. Jim's work really shakes things up. it's not always popular with lawyers. It exposes sometimes uncomfortable truths about our profession. One article in the Yale Law Journal used a randomized control trial to show that an offer of representation by a legal services provider in an unemployment benefits litigation had no statistically significant effect on the probability of a favorable outcome for the client. The next year in Harvard, he showed, conversely, that tenants in eviction proceedings in Massachusetts Housing Court do better with a lawyer than without. One of the things you know about Jim, this is something that you can take to the bank, is that he goes where the evidence takes him and he seeks the truth. Jim and the Access to Justice Lab are now conducting randomized control trials to examine the effects of legal representation in various areas: financial distress, intimate partner violence, pretrial release, debt collection, divorce, Social Security, disability, among other issues. As our colleague Chris Bavitz said, quote, Jim's research serves as a guidepost for those committed to innovation, technological advancement, and access to justice. His work is more vital than ever in an era of big data and algorithmic decision-making, where transparency and scrutiny are crucial to ensuring fairness and equity. And one of the most important parts of this work is the comparison. Now I'm not quoting anymore. And one of the most important parts of this work is the comparison of whether legal representation works better or worse than legal self-help materials in debt collection proceedings. I have to say that one of the most endearing parts of the self-help material is a cartoon known as, yes, the Blob. So funny as it sounds, the self-help materials, including the Blob, reflect the rigorous use of the insights of behavioral psychology, behavioral science, psychology, and public health, and of course, of rigorous empirical testing. Jim's work does not stop with testing for efficacy. He also is thinking creatively about how to give those in need of legal services agency in the legal process, and he proposes innovative solutions. In this important way, Jim is carrying on the noble work and the ideals that Bill Green cared most about. Here's the bottom line about Jim and the Access to Justice Lab. They want to challenge the notion that full legal representation is a requirement in every possible legal setting. Sometimes it is, and sometimes it's not. And they want to show it empirically. He told Harvard Law Today, and I love this quote, that the proposition that everybody needs a lawyer in every instance is, quote, like giving penicillin to every sick patient. You have to work a little harder than that. And that's what Jim does. He works very hard. He works hard for truth and justice. And I'm extremely proud that he is my colleague and my friend. And without further delay, I would like to present the Honorable S. William Green, Professor of Public Law, Jim Greiner.
Thank you all for coming. I am humbled by the introduction. I'm humbled by the presence of Pat Green here today. Thank you very much. Of Cynthia Green-Collin. Thank you very much. Of my wife, Jennifer Lewis, and of all of you here. Thank you very much. I will begin shortly to sweat and agitate and fidget if I don't get some questions. So let me invite each of you, if you have questions that you'd like to ask, and I can try to provide answers. Please don't hesitate. I will make sure that I end early enough to specific for questions, but I would feel much better. You would help me deliver this lecture if you can interrupt me with questions as we go along the way, and I'll feel much better about it. It is a tough time to use slides. Let me try it this way. Nope. Let me try it this way. I got it. There? Yeah. It is a tough time for evidence-based thinking in the United States right now. I was going to read this quote, but I don't think I need to. It's just sort of breathtaking on its own. And for those of you who do not follow murder rates, the murder rate peaked in roughly the early 1990s and has been falling very, very steadily and substantially since then. There has been statistical noise recently, but this is demonstrably false statement. If you don't, I don't know yet, I haven't even defined what evidence-based means, but I know that it is not in favor simply by the fact that the phrase is apparently toxic. The phrase evidence-based on its own is apparently toxic. And so, as I mentioned, it's a tough time to be thinking evidence-based. Is that across our entire government? Maybe it's just the political branches. No, it's not. It's not just the political branches. It's the judiciary as well, and in fact, the legal profession, the United States legal profession, although I'll hope to convince you in the first portion of this talk that at least with respect to the legal profession, that is not a new phenomenon. This is not a new phenomenon. The aversion and disdain that the legal profession has for evidence-based thinking is not new. It's been sustained for a long time. Here's a quote that I think is most disturbing of all because perhaps I expected better of the person who issued it. This is Chief Justice John Roberts' comment on a near consensus set of principles within political science about how to measure partisan gerrymandering. And in recent oral argument, he dismissed the entire field as sociological gobbledygook, blaming his, quote, my educational background. And this does not make me optimistic, although I hope by the end of the talk that we'll have more cause for optimism. It's a tough time for evidence-based thinking. Perhaps the latter, you could say, is just a stray remark. Maybe this is just something that happened, in the judiciary at a moment of time. Perhaps it was meant for levity. It's not a stray remark. It's a way that judges and lawyers think, and we need to think differently. That's going to be the theme of this talk, that there are consequences to our choice of epistemology, instrumental epistemology, and we need to change. Let me show you an example, and I will show you an example a little bit later of the disdain for evidence-based thinking in the judiciary. Before I do that, is it a problem of the political right? Because all of the three quotes that I showed to you might have been thought of as portions of the conservative movement. Surely progressive lawyers facilitate and seek out evidence-based thinking right now. And I think the answer is no. And in fact, most of the most strenuous opposition that the Access to Justice Lab receives to its work, which I'll hope to talk about, comes from folks that identify on the political left, the progressive movement. This is a slide to give you an example. This is a slide that I've routinely showed in attempting to explain one of the Access to Justice Lab's most aggressive studies, in which what we hope to do is to randomize legal professional decision-making on a triage decision, who gets what level of service, versus randomized decision-making. One way to think about this would be randomizing a professional decision against a machine to see which is better, where the machine is the dumbest machine ever invented, another randomizer. And the opposition that we've gotten to when we say that this study is ethical, when we argue that this study is ethical, we point out that the representation rate among domestic violence survivors for seeking civil protection orders in this setting, so these are folks who have suffered domestic violence allegedly in their lives and are seeking protection orders. The representation rate is around 18%, so over 80% of them go unrepresented. They deal with these court processes on their own. And the opposition that we get is it's unethical to deprive them of representation based on a randomizer, when I think it's fairly obvious that what's depriving people of representation is a severe shortage of services, not randomization. The other, more poignant, more pointed opposition that we got from, and this was, again, members of who would self-identify on the political left, which is why I'm telling this story, is I'm worried about, oops, sorry. And this actually, you have to see the slide to make sense. I'm worried about this one. This is an actual comment that I got. I'm worried about that one right there in the corner. Which, in a sense, continues to baffle me utterly. I mean, this is a representation of 30 cases. It's an otherwise faceless figure that's completely identical to 4 solid rows of faceless figures. But the instinct, the urge to identify one particular person and provide sympathy, a sympathetic response, was such that it trumped the concern that we might have for the entire population of people that were in this system, and the fact that perhaps, we don't know until we investigate, perhaps because of a failure to use evidence-based thinking, many of these folks who could have court protection don't have it without the injection of additional resources. That we have, whatever resources we have, since we're not maximizing their utility, we're not maximizing the use of them, there are people that don't have civil protection orders that could have them. And that's what we're talking about here. That's what's at stake. People that don't have public benefits who could have them, people that don't have court protection who could have them, people who are suffering eviction judgments from their apartments unnecessarily without the additional injection of resources, people who might be let free earlier or at all in criminal cases, but are not let free because we don't have the knowledge base to decide who should be let free and how to guide judges in making that decision when they are arrested and awaiting trial in their criminal cases. This is what's at issue. The consequences are severe. What does it mean to be evidence-based? So if I say that the legal profession is not evidence-based and that there are consequences to it, I should have to define that term. What does it mean to be evidence-based? And I think in order to understand that, you need to understand 2 competing visions of what I call instrumental epistemology. For my epistemology, I'm not talking about knowledge about how to live the good life. That's not what I'm talking about. There are lots of folks that think about that. Bless them for doing so. I went to stat school, so not what we learned about there. What I think about instead is how do we get from here to there? What are the facts that we need in order to understand how to get from here to there? What are the policies that we need to understand whether they work? That's what I mean by instrumental epistemology. And there are 2 competing visions. These are stylized, but they're communicative. One is to reify professional judgment. What I mean by that is because we are professionals, because we went to school, because we have to pass tests like the bar, because we go out and we see things in the world and the world depends upon our judgments, we know what's true because of what we see and what the cool people tell us is true. And that's basically what we know in terms of instrumental epistemology. And there is a second competing vision, which is that there should be a role for rigorous empirical techniques, and that what you see and what cool people tell you is true is not the only source of instrumental epistemological truth. And the latter, view number 2, is the one that I'm calling evidence-based. So that's just pure definition of terms, okay? That's what I think is at stake. What does it mean then? Well, how would we know whether a field is evidence-based? And I think the randomized control trial, the use of a randomized control trial, is a key indicator in whether a field, so just describing whether a field is evidence-based, it's a key indicator. Now, I need to do 2 things in order to try to persuade you of that. One is I need to tell you what is a randomized control trial. And the second is I need to say, why is its use important for deciding whether a field is evidence-based? Okay, so that's what I'm going to do next. What is it, and why does it matter in terms of assessing whether a field is evidence-based? Let me talk about the first one first. Again, I'm just waiting for the slide to transition. This is what a randomized control trial is. Basically, when we have two or more, but I'll just say two to start out with, two or more things that we could do to a case, to a client, for a client, or for something else, or whatever it is. So for a case, we might be deciding whether we should use a risk assessment score or whether we should not use a risk assessment score, and deciding whether to release an arrestee while that arrestee awaits disposition of a criminal case. For a client, we might be deciding, or a potential client, we might be deciding, are we going to offer a survivor of domestic violence full representation, or are we going to use only self-help materials? Because we don't have enough to offer full representation to everyone. We have to have some sort of decision-making apparatus between treatment A and treatment B. The view number one that I mentioned, the view that reifies professional judgment, says only a professional can legally, ethically, morally, whatever it is, make that judgment. And of course, the randomized control trial would say that sometimes what we can do is we can use a randomizer, a coin flip, a die roll, whatever it is, to make that judgment, okay, about who gets what. And a key, I think, to the opposition within the legal profession to the use of the randomized control trial and evidence-based thinking is the very fact of that substitution. And I'll be talking about that in just a moment. That the professional, for the duration of the randomized control trial, must give up her decision-making authority on a key piece of what happens with the client, or the judge must give up her decision-making authority on a key piece of what happens with the case. And there you can see why a professional whose identity, very sense of self, is bound up in the idea of, I have superior knowledge, I have the good of my client in my heart and as my guiding principle, and yet I am not going to get to make the fundamental decision about what form of treatment my client receives. You can see why that would clang, resist, rub the wrong way the professional, the highly trained professional. So that's what I mean by a randomized control trial. Why is it consequential? What happens if we don't use it? That's actually kind of easy. We get the wrong answer. We don't know what's going on. We might, by luck, get the right answer if we don't use randomized control trials. That clock is right twice a day. I would not want to look at it in order to find out what time it is. And if we don't use randomization, especially when we can, we are basically looking at that clock to figure out what time it is. It might be right, but it would be by pure luck. So what's an example of how the failure to use randomization might misguide us? I pick one that I think is easy upon the lawyer identity. And so I'll share that with you. I can give you an example. Let's talk about whether juveniles are helped by having a lawyer represent them in delinquency cases. Let's talk about that. The basic question here is, should they be provided lawyers? Should we assign juveniles? Is it beneficial to the juvenile defendant, although they're not called that in juvenile proceedings, is it beneficial to the juvenile defendant to have a lawyer? And there are 11 non-randomized observational studies that go to this question. 5 of them, at my last count, showed no effect whatsoever at having a lawyer. 6 of them, so the majority of them, suggested that the group with the lawyer had a higher rate of incarceration. Okay? Do you believe that? Do you believe that on the basis of that research, lawyers cause incarceration for juvenile defendants? I don't. So what could have happened? Why could it be that so many studies would show that an association between the provision of a lawyer and the higher rate of incarceration? And I think I know the answer, although I don't know for sure without further investigation, but I think I know the answer. And you have to think about how it is that juveniles get assigned lawyers in delinquency cases. And basically a little bit of constitutional law here, under a case called In re Galt, that was decided in the late 1960s. There is a constitutional violation if a judge incarcerates a juvenile in a proceeding in which that juvenile does not have counsel. There is no constitutional violation if the juvenile is not incarcerated. So what does a judge do early on in the case? The judge takes an early look at the case, says, I might have to incarcerate this kid, and gives the kid a lawyer. In which case, the threat of incarceration is causing the lawyer, not the lawyer causing the incarceration. How then do we decide whether lawyers are beneficial to juveniles? The only way to know is to randomize who gets the lawyer and who doesn't. And that was actually done, just as or prior to in Ray Galt. And it turned out 2 studies came up with conflicting results. The point, though, is that if we don't randomize, we get the wrong answer. Is it only lawyers that run into this problem? Or is this true of all other professions? And what have other professions done when they've encountered this sort of thing? And in fact, it's not just lawyers. Lots of professions have recognized that they're getting the wrong answer if they don't randomize. So a bad joke might begin: a doctor and a criminologist and public health specialist and a fitness expert and a development economist walk into a bar. Here they're out in the desert. And the doctor is going to lead all of the others out into the oasis, except for Lady Justice, who's going to stay where she is, unless we do something. So what happens in other professions until they begin to use RCTs? We get disaster stories, both in the sense of doing things that turn out to be ineffective or potentially harmful, or failing to do things that could really benefit people. My favorite of this particular story from the medical profession, because it affects my own family, is peanuts for kids. My 8-year-old daughter is allergic to peanuts. And had we known what we know now, she might not now be allergic to peanuts. How does that work? Well, when my 8-year-old daughter was 1 or 2 years old, we received the standard advice that everybody in pediatric medicine knew was the right thing to do when you faced a young child with a peanut allergy. Keep the kid away from peanuts. If you've got a severe peanut allergy or potentially severe peanut allergy, don't risk exposing the kid to peanuts. A randomized control trial, however, demonstrated that for a great many children with peanut allergies, not all of them, but a great many, and so you have to be careful, if you introduce the child to peanuts early in its life, 1, 2 years old, if you begin then, you train the body that the peanut is not poison, and you cure the body of the peanut allergy. That took a randomized control trial to prove, precisely because it was contrary to the received, accepted professional judgment of the profession. Is it just medicine that has figured this out? How many of you have heard of a program called either a TV program or an actual implementation, program called Scared Straight? The basic idea is that we'll take kids accused of crimes, put them into jails, not literally incarcerate them, take them into jails, have prisoners yell at them, and scare them straight. Pretty well established that the best thing you can say for this program is that it has no effect. Likely, though, it increases recidivism rates. It causes more crime. And criminology took randomized control trials to figure that out. It's maybe my favorite cartoon ever coming up. This is a early teen or preteen girl with a robot baby. This is another program designed to, from public health, designed to reduce early teen pregnancy. And the idea is that we're going to give a teenage girl a robot baby, pretty expensive, $2,000 to $3,000 each. And we're going to have the teen or preteen girl take the robot baby home over the weekend, where the baby poops and pees and does other things in the middle of the night, yells and screams. And the preteen girl's grade is based on how well she takes care of the baby, which really expensive models can actually record. Early evidence out of Australia, only one randomized study done so far suggests that this may increase pregnancy rates. So far, the best you can say of it from the randomized control trial, very well done, long follow-up study, 8-year follow-up study, is that it has no effect, and this is an expensive waste of money, may actually increase pregnancy rates. Why? Perhaps because she comes from a home where she wasn't getting attention until she has the robot baby. She gets attention when she has it, and she says, I want to do that again. Fitbits, if you're already obese, don't help you lose weight. This is one of the more devastating stories, folks winning Nobel Prizes or getting lots and lots of credit about something called microcredit, a really terrific way of giving small loans to especially female would-be entrepreneurs in developing countries in order to try to increase their household income as measured by household consumption. 6 randomized studies, 6 different countries, no effect. So this is now maybe the doctor, the physician leading the economist, the fitness expert, the criminologist out into the oasis, but law standing still. Sorry. Why is it important, again, let me go back, why is it important to measure the status of a field in terms of its evidence base, whether it is an evidence-based field, in terms of using randomized studies? How does that challenge the field or define the field? Well, I think it does so for 2 reasons. One is because the field has to give up its judgment, that's what I mentioned before, about who gets what. The field is basically putting its trust in something other than its own observations to find out truth. For law, this is a particular challenge, though, not just because we have to give up our professional judgment, but because in law we have a strong norm towards formal equality, towards the idea that we have to treat like cases alike. That is what our equality norm means. We embody that in constitutional law for state actors in the Equal Protection Clause. We still have to do a lot of work to define what like cases are. What the randomized control trial, though, does is it treats like cases differently. That is precisely the way it generates knowledge. And so there is a fundamental challenge not just to our identities as professionals, but to deeply held fundamental values. And we have to acknowledge that those values, when we don't know answers, are going to have to be balanced against our need for answers. So as I said, it's a tough time for evidence-based thinking, and I mentioned that there was what you might characterize as a stray remark, or perhaps worse, among the judiciary in terms of reaction to evidence, strong evidence. I'd now like to show you 2 other pieces of information that suggest this remark by Chief Justice Roberts was not an isolated incident, that this is a deeply held thing, this is a deeply held view within the legal profession. The anecdote that I'll show you before I show you some stats comes from something called the Civil Appeals Management Program. And this is from the United States Court of Appeals from the Second Circuit, one of the most powerful courts in the country and in the world, one where you would expect the highest standards of thinking to have occurred. And the story here is that the chief judge for the United States Court of Appeals for the Second Circuit, and by the way, sorry, let me step back for a minute. What do I want to get out of this example? What do I want to show you? I want to show you what the reaction in the legal profession is to rigorous RCT-based evidence when we have it. What do we as legal professionals do when we have that evidence? To suggest to you that that is indicative about how we react to the idea of an evidence-based field. The United States Court of Appeals chief judge for the Second Circuit was worried about case overload, case volume, case backup. And so what did he do? He ordered the parties in 5 cases and their attorneys to appear in front of him at what we would now call a settlement conference. And lo and behold, he settled all 5 cases personally. They settled by the end of the conference. Now note, the judge might have been the one that was sitting on the subsequent decision-making panel. He did this when the panel had not yet been decided. But he was able to settle those 5 cases. So that's what he saw. That's what he observed, right? That was his personal professional experience. He then went to the Administrative Office of the United States Courts and says, please give me funding so that I can hire 2 lawyers who will do this settlement conference thing in appeals for the Second Circuit. And I predict, in writing he said, I predict that this will reduce the oral argument rate in the Second Circuit proceedings by 25 percentage points. In a minimum, the absolute bare minimum, the lowest possible number that I can tolerate in terms of saying this program was cost justified is 10 percentage points. Okay, so 25 is a prediction, bare minimum is 10. Somehow, and I haven't quite been able to fully uncover this, there was a randomized control trial ordered, and this was unheard of. It still is unheard of, and I'll show you that in just a minute. The randomized control trial ordered of this program, and the randomized control trial showed not just no 25% reduction, not just no 10% reduction, but no reduction whatsoever in oral argument rates when you compare to the Civil Appeals Management Group versus the No Civil Appeals Management Group, the CAMP group versus the No CAMP group. So what was the reaction of the Second Circuit judge and of the judiciary as a whole to that finding? The Second Circuit, this is in publication from the Federal Judicial Center, the judiciary's scientific arm, the Federal Judiciary's scientific arm. We remain committed to the CAMP concept and maintain the program. The Second Circuit, in its publications, credited CAMP for its unique success of closing more cases than other circuits and asked for more funding to make the program permanent. The funders said, not so sure about that. Maybe we'll give it to you, but at least we want to have a second RCT. So the second RCT was begun, again evaluating CAMP, and it got about 2/3 to 3/4 of the way through the second RCT before the Second Circuit judge was successfully able to kill not the program, but the evaluation. The program kept going. The evaluation died. But because it was gone 2/3 to 3/4 of the way through, there was enough data to at least analyze something, and lo and behold, CAMP failed the pre-specified, by hair, but it failed the pre-specified success criteria. It did not settle enough cases, and it was just borderline statistically significant. So what is the reaction of the judiciary now? The Federal Judicial Center, again, the scientific arm of the federal judiciary's report said the potential of CAMP is so great that all persons that care about caseloads should pay attention to CAMP. And that pointing to the benefits disclosed by the RCTs. That is our professional judgment reaction to hardcore evidence when we have it. Let me go back to this slide again. Why is it important for a field to be evidence-based? Surely we use the RCT routinely in law. And I think you can guess by now, after all the depressing information that I've given you and the depressing answers, the answer is no, we don't. Let's contrast law with medicine on this score. 2 years apart, in 1931 and in 1933, both law and medicine had their first publications in what we would now recognize as modern journals, based on randomization, randomization-based inference. And the question is, if you had been standing in the worlds in which we now operate in 1934, you would have been hard-pressed to make a prediction as to which field would become evidence-based, medicine or law. Note that in 1930s, if you had uttered the phrase medical science, no one would have known what you were talking about. Medicine was not a science. How many RCTs in medicine since the 1930s? How many RCTs in law? And I think you can guess the answer. In medicine, there are too many to count. And I think we see the benefits to that turn towards evidence-based thinking in medicine. We live longer. We are alive longer, and we live better and more complete lives as a result of that turn to evidence-based thinking. In law, we have a grand total of 50. since the beginning of time. 50, wow, sounds like a minute. Well, 50 in criminal law and civil law, 50 in in every possible field of civil law, so family law, summary eviction, housing disputes, government benefits, every single type, alternative dispute resolution, regular dispute resolution, different forms of legal representation, et cetera. No, it's a drop in the bucket. It is nothing to even begin to solve the ocean of our ignorance in law about what works. 50 is not enough. The United States legal profession is not evidence-based. Well, is that bad? Yes. As the next slide will tell you, yes, it's bad. Why? Well, we've gone over some of this, and we'll skip through as fast as the slides will let me. What happens in other fields, and again, using medicine as an example here, what happens in other fields when we don't do evidence-based thinking? In medicine right now, by way of example, 90% of cancer drugs that are considered to be sufficiently reliable to be tested and emerge from the laboratory to be tested in human beings fail to demonstrate that they are safe and effective. So we get 1 out of 10 of those right. Where do they fail it? Where do they most likely fail? Do they fail early on where we could save a lot of money and go on to the next one? Alas, no. The biggest drop-off, in other words, almost all of them, 70% of new proposals, fail in randomized human testing. In other words, we don't know whether they work until we actually do hardcore testing. But this is what we do in law. And it makes me wonder, what are we doing to people? What are we doing to them, with them? Well, what can we do about this situation besides just sit around and be depressed? We can draw another lesson from medicine. Medicine made a self-conscious decision to transform itself from an art into a science. It was not an inevitable thing. It was physicians fighting an intellectual civil war, a bloody, scratch-your-eyes-out intellectual civil war for the soul of the medical profession. There were many, many people who disagreed, and they took the building blocks of chemistry, biology, engineering, and other hard sciences, what we now think of as hard sciences. They evaluated and tested via the RCT. It took 4 decades to win a battle just in the areas of new medical devices and new drugs. It took much longer. We're still fighting that battle in the area of everyday, day-to-day medical practices. Do we have to wait that long in law? Well, if we do, let's get started now. I will likely be dead before we see the revolution happen. But I'd hope that we can do something. I'd like to see it happen. I'd like to see law transform itself into an evidence-based field and live long enough to do it. Can we take the raw materials of behavioralism, psychology, economics, sociology, et cetera, all of the other fields that we could use as our raw materials? Can we test them via the randomized control trial? Can we go faster than medicine did? I think the answer is yes. One aside here, why not just wait on the market? Why can't we just have the market solve this for us? Obviously, lawyers operate in markets, and we could just say that the market will discipline lawyers and force them to adopt efficient principles. That's what markets are for. Well, the answer is no, because in the law, we pretty severely messed up markets. My colleagues here from the Center on the Legal Profession have published about such things extensively. And there is no market for low-income services. In fact, the lawyers are scarce, and the customers want the lawyers. It's a reverse market. The customers compete with the lawyers, not the lawyers compete with the customers. On top of that, with apologies, and this is perhaps a little flip, I don't really care if rich people waste their money. We should be caring about folks that cannot afford to hire lawyers to interact with the legal system for them. We need the Access to Justice Lab. the Access to Justice Lab was founded here at Harvard Law School. It could exist nowhere but here as a starting point. There is no brand name as strong as Harvard Law School's. There is no other place where we have the accumulation and concentration of size and talent in our student body and the energy, and I am extremely proud that it's here. What are our objectives in the Access to Justice Lab? It is, as I said, to alter the bench and the bar's epistemology, to reduce the hostility to ideas from other fields in the randomized control trial, to establish a role for rigorous empiricism. For those of you unfamiliar with the lab's work, we do all sorts of things. We theorize. We have to in order to make a randomized control trial make sense, to know what we're testing. We incorporate lessons from other fields. And I did have to have one real clear picture of Blob, since John mentioned it, the Blob and Fat Cat and the Judge, as an example of the cartoon-based self-help materials that we design. And we test and we test and we test our own interventions and other folks' interventions. We do all sorts of work, federal, state, civil, criminal, ADR, traditional litigation, you name it, all stages of civil legal services. We have these studies out into the field. For lawyers and judges who would look at us and say, you can't randomize in law, we are disproving that by example. We do not stop at the courthouse steps. We simply go beyond that and say, are people's lives being improved by the legal interventions that we propose, that we evaluate? And perhaps the greatest part about the lab, the most fun, and if this is a 40-year civil war to be fought, the only thing that matters is that we have at any given time, we have 70 to 75 students involved in lab work. Because if it is going to take that long, nothing that I do matters. It is only you students who have come here and students working with lab, you are the only ones that matter, because it's going to take too long for us to ever see it. Now I have sweat, fidgeted and agitated and twitched. Let me stop and take questions. And that,
In your comparison to law and medicine, do you think that behavioral psychology and economics have the same salience as biology and microbiology and so forth for medicine? Is it likely to be? Did you hear what I said?
yeah, I did. So the question is whether the comparison between law and medicine is a fair one. Is biology and behavioral economics and psychology, or chemistry on the medicine side, are they perhaps I'm taking this question to mean firmer, more reliable bases upon which to base professional recommendations for medicine
yes,
than the corresponding fields that I cited as the potential foundation fields in law. 15 years ago, I would have had, maybe 20 years ago, I would have had more nervousness. I still would have, in answering the question, yes, that it is a fair comparison. Now I'm less nervous because recent demonstrations about how everything from bacteria to the human body itself reacts severely to what we do to it. Bacteria, antibiotic-resistant bacteria have emerged. Biochemistry, we're finding out that even if you understand the entire genome, there are proteins that turn genes on and off. And those are in some sense fragile, and they're not durable in the sense that they're resistant to external sources and environments, et cetera. And so the sad truth, or perhaps the optimistic truth, depending on your view, is that everything is fragile. And that things that we thought that were rock solid in the sense of hard sciences, that phrase hard science, is itself somewhat fragile and soft. Nevertheless, we can see the benefits of evidence-based thinking in medicine. As I mentioned, I think we can attribute at least part of our dramatically increased lifespans over the past century and our dramatically increased physical quality of life to medicine. And I am optimistic that we can do a substantial amount of good in law by thinking this way. Whether we will achieve the same kind of revolution that medicine did, I'm not sure. Again, with using those building blocks and constant testing. This is Dick Fallon.
So, Jim, it's a wonderful lecture, and you persuade me thoroughly that we need to move in this direction. And so I've got two questions related, I think, about what cautions we ought to be demonstrating or heeding as we move in this direction. The first question would be, under what circumstances would you not want to do randomized control trials? I mean, there must be some situations in law, as in medicine, when you would think it's just too risky based on some perhaps intuitive professional judgment. And so maybe you could say a little bit about that. And then the second thing, imagine that I was a judge and somebody came to me and said, I want to do a randomized control trial. As I try to read empirical literature, studies that people have done in various areas related to my professional work, and try to figure out whether they're good studies or not, I find that I'm hopeless. And if I came to you, you would tell me that studies that looked like good studies to me weren't good studies. When I go to faculty workshops, you and other colleagues who are experts in these matters repeatedly demonstrate that what looked to me like impressive methodology actually wasn't impressive methodology. So what should judges do to make sure that they don't go heading off down the wrong road, all on the assumption that you're basically right in your fundamental hypothesis?
Absolutely. So on your first question, I'm heartened that my colleague Charles Fried is here. He's written a canonical book that was republished, but canonical back in 1970. Was that 74, called Medical Experimentation, that explored precisely these issues about when is it permissible on a rationale of equipoise to pursue a randomized control trial. Now, what I mean by what Charles meant by equipoise was some state of uncertainty. Now, how much uncertainty is to be debated, but some state of uncertainty about which of two treatments might be the best for a particular patient or for a set of patients as a whole. You can think of cases the same way. So you might say, well, then, when there's absolutely no equipoise, when there is sufficient certainty, it might not be ethical. However, you might also want to look at scarcity. So when there is scarcity in some service provision, it is usually permissible. It may not be ethically optimal, but it is usually ethically permissible to randomize, especially if you can generate some sort of information by doing so. And some justifications for randomization are used even when we think we might know how to allocate a resource better than randomization would give us, simply because we don't want to be responsible for the decision. And then you could use it. So this is all answering the flip side of your question. The question you ask is, when would we not randomize? One place that I've encountered is when the potential harm to the participants is so obvious and so potentially certain that you would not randomize. I had the opportunity to pursue a study in whether the provision of legal assistance made it more likely that asylum applications would be granted. And the problem with it is that for the no legal assistance group, we needed to track their outcomes. And in order to do that, we needed to potentially provide ICE with name and address information about folks who had applied for asylum, even though their asylum applications might not have been successful. Now, I was not going to do that study, right, because I fear about what might happen to them if they're. So certainly harm to the subjects is a major factor. Nevertheless, the other factor, more general, is if you have sufficient certainty and you don't have a shortage, in no serious sense do you have a shortage, then it is probably not a good idea to pursue an RCT just to verify the professional judgment. Again, the debate becomes how much certainty is there. And I cite you to suggestion that we should probably have less certainty than we do to the example of heart stents for treating angina. There have now been randomized studies that suggest that stenting just to treat angina in the chest, not to treat more serious conditions, simply doesn't work despite the professional judgment to it. And there was a study done in Europe that could not have been authorized in the United States because of our squeamishness about this point, that demonstrated that it didn't work because there was so much consensus among certain portions of the profession. So again, when you're to answer your question directly, when you're really sure and when you don't have a shortage, then you might want to take a hard look at whether you should pursue an RCT. To answer your second question, a general idea, when your second question was, how should we know which are good studies and which weren't? The more Greek letters, the more math you see, the more suspicious you should be. The nice thing about randomized studies is that all the work goes into the construction of the field operation and the running of the field operation, and that you have a treated group and you have a control group, or you have multiple groups. Most of the time, not all of the time, most of the time, a monkey could analyze the data afterwards. That really, if you put in the hard work to constructing the field operation, you are probably going to find out enough information just by looking at the average of the one group versus the average of another group. Not always true, but most of the time. So generally, you look for randomization, not quasi-randomized, not quasi-experimental. Those are code words for not randomized. You look for randomization when it's possible. It's not always possible, when it's possible. And you look for simple, non-fancy stats, and those are going to be good guideposts for the credibility of the study. Oh, sorry. This is Charles Freed.
In medicine, and particularly drugs, but in medicine, the RCT has become what's called the gold standard. But you indicated a reservation. When you are so certain, then you're not going to do it. And in medicine, they found out that those are exactly the cases where they should do it. Mm-hmm. Fine. Nevertheless, and you indicated this as well, you're very, very much alive to it, there are situations where the randomization itself raises such problems, such squeamishness, such ethical doubts about the appropriateness of withholding what many people think is a good on this basis, that we don't go ahead. And you've recognized that. Well, there are alternative ways of testing this. There can be retrospective tests. You can do historical quasi-randomization, all of that. And you, in your remarks, cast some aspersions on that. You sneered, and understandably. But I wonder if, to quote Tom Lehrer, anything you can do, I can do meta. Mm-hmm. And I wonder if we could not do meta by looking at the quasi-randomized studies and the truly randomized studies, randomized between the two kinds of studies, and see how often we get satisfactory results that way.
Mm-hmm. I think we can actually do better in some settings, and I think we have. So I invite you to look at the work of our colleague Crystal Yang, for instance, in things like the effectiveness of bankruptcy in solving downstream financial problems for consumers. And what Crystal's work often does is it takes advantage of randomization that exists in the world, for instance, of judges, very permissive judges in affirming bankruptcy plans versus very stringent judges in affirming bankruptcy plans, when bankruptcy cases are randomly assigned to these two sets of judges, and then uses that randomization and does two things. Runs a quote-unquote randomized study based on the randomization that is already out there in the world, and then on the same fact pattern, using data, runs the observational study that one would run if one did not have the randomization, and says, do they come up with the same answer? The problem is, without some other source of super godlike truth generation, you don't know which of those answers is correct. You have the randomized study and you have the observational study. Frequently, though, I will say that when I have seen that technique that Crystal is deploying done, the answers do not match. And I at least trust the randomized study, because there is typically an easy story to understand to tell why the non-randomized study came up with the results that it did, usually almost always some kind of selection effect, some kind of obvious selection effect, such as, the person opting into bankruptcy is more likely to have greater motivation, greater strength of social networks, or something like that, and that confounds the observational study. So I think we don't even have to randomize observational study versus randomized study. We can often do them simultaneously on the same fact pattern and compare the results, and that's even better. The only reason we really randomize, and the reason to use it, is because you can't observe the same unit when it undergoes treatment A and treatment B at the same time. If you could do that, you would never need to randomize. You could just say the same person, same time, I'll find out what that person gets with cancer drug A, and I'll also know what that person gets with cancer drug B. And the fundamental problem that we're trying to solve with randomization is we can't see both of those simultaneously. But in the fact pattern you're describing with a study, we can. And they frequently don't match, and you're right, and perhaps for rhetorical reasons, I've been a little bit more negative about observational studies than is really warranted. But it frequently in the fact pattern that you are suggesting, the answers don't match, and I know which one I trust. Lucian Bebchuk.
A couple of questions. One, connected to Charles' question, I think that your view that for evidence-based we must have randomized control. I mean, everybody would agree it's wonderful if we can have it. But in the social sciences, there are many areas where we don't have, and people would say it's evidence-based. The Federal Reserve Board has hundreds, probably thousands of empirical economists who produce a lot of evidence. We rely on it. And for understandable reasons, we can't have randomization with central bank interest rates. Secondly, my sense is, that your area, access to justice and to legal services, that really lends itself to controlled experiments, because people are happy to have, everybody would agree to get legal services when otherwise they might not have them. But there are many areas of the law where you can't really imagine having a randomized experiment. I was thinking, I was thinking about, I couldn't come up with a rule in corporate law that you could have a randomized experiment. And the reason is, they think that in medicine, people agree to have this experiment. And because at that stage, it seems like on expected value basis it might benefit. In law, in many situations, you have more than one party. And you can consider a rule that might be good overall and you want to test, but would probably hurt one of the parties. And that party wouldn't agree to have a randomized experiment conducted with them. And you say, if you pass it for everyone, you have no choice, but otherwise they're not going to participate in the experiment.
So 2 thoughts that I think address both of your questions. One is, we can randomize a lot more often than we are right now. And I think we can be much more imaginative than we are right now. And the second is, we do not need, nor should we need, consent in every case in which we randomize. So to give you an example of the first one, the thing that you cited, corporation rules. The SEC has done a randomized study close to randomized. It could, at the last minute, it lost its nerve and couldn't quite do a dice roll. So instead what it did is 1 out of every 3. It did the first one and the 4th one and the 7th one and the 10th one and ranked people in a certain way, which was supposed to reproduce randomization. It just lost its nerve. About the imposition of SEC regulations on publicly traded companies. In other words, it randomized law. And it did it. And it could do it again. The SEC could do it. Agencies can do it, right? If they are in the sort of equipoise, or if there are other legal and ethical justifications that are there. But the idea that we can't randomize regulations, we can't randomize law is simply wrong, and it's belied by facts. We've done it before. The SEC has done it before, right? So certainly there are certain things that we can't randomize. We can't randomize, for instance, whether the European Central Bank is located in Europe. What would the European Central Bank do if it were located in the United States, right? I agree, and it's why most of my talk, I think, was limited to the United States legal profession, where we could randomize a great deal more often than we can. It baffles me, and again, if I cared, I don't, because if rich people want to waste their money, that's fine, but if it baffles me that insurance companies are not regularly randomizing which lawyers they hire to settle vast portfolios of, say, car insurance claims. Maybe they are, and they're just not letting anybody know it, but why in the world aren't they? Right? We could randomize legal regulations itself. We have to face head on that in an ex post sense, not in an ex ante sense, but in an ex post sense, that is not going to be consistent with conventional understandings of equal protection. We are going to have the same, the relevantly similar cases treated differently in an ex post sense. The second thing is, when could we do it? And we can do it a lot. I mean, this is repeating. We could do it a lot more often than we are justifiably. We can ethically justify. We don't have to have consent in every circumstance. Think about, we have a randomized study going on right now where we are randomizing the use of a pretrial risk assessment score in providing the pretrial risk assessment score to judges who are deciding whether to release criminal defendants who have just been arrested. So this is the bail decision, right? And we are randomizing whether the judge has the risk assessment score or doesn't have the risk assessment score. We do not ask for consent by the arrestee. The arrestee is in an incredibly coercive environment already. The arrestee has absolutely no control over what happens to her, right? We are in a state of equipoise. We do not know whether the provision of the pretrial risk assessment score will cause lower incarceration rates, lower new criminal activity rates, lower failure to appeal rates. We don't know that. We don't know whether that pretrial risk assessment score will do what many have predicted that it will do, and that is worsen the racial inequalities that are already inherent in our criminal justice system. We don't know that. We don't ask for consent. The SEC did not ask for consent when it almost randomized the imposition of the law. There are many, many situations in which the law is and must be coercive. And when it is coercive, we frequently will not have to ask for consent.
All right, thank you. I want to thank the S. William Green Professor of Public Law for that illuminating and interesting lecture. And there's one more piece of the ceremony that we need to do. And so when I was the person giving the chair lecture, my dean, Martha Minow, told me that I could not get the chair without the chair lecture. So I'm going to continue that tradition. And now that you have done the chair lecture, you get an actual chair.
Actual chair.
And on the back, it says your name and the name of your chair. I think it's a very attractive piece of furniture. And so with that, we will adjourn to the next room. Please stay for refreshments, beverages, and let's once again thank
you for
Jim
coming.
Greiner.